question now is, would you have the courage, the guts and nerve to file cases against these persons who were instrumental in you getting this ombudsman post?
I think that is not I mean, cases are there because they have to be filed. And if the evidence is out in the open, it's already established. What stops us from doing the right thing? But we will do what we have to do. I think that's the ultimate job of the ombudsman.
Last question, Mr. Secretary. So now you are the ombudsman. So what significant development in your life do you think that would make you decide to quit the post? Meaning to say you would not finish the 7-year term.
Maybe my health only. If my health will not be cooperative, but so far, I've been very healthy. I have weathered a lot of storms in terms of my physical well-being. But that's the only thing that can stop me. But otherwise, I want to stay put.
Thank you, and good luck, Secretary.
Thank you, Attorney Firme. Our last interviewer is the Honorable Justice Jose Catral Mendoza.
Thank you very much, Attorney Marife. Good morning, Secretary.
Morning, sir.
I represent the retired justices of the Supreme Court, and some of them, of course, their questions through me, addressed to you. One question is, can you distinguish the right to remain silent from the right against self-incrimination?
That's a situation. That's what the situation would call for. I believe that a person who has been arrested should invoke the right to remain silent until he is able to get counsel. And the right to self-incrimination will be in other fora. I think that the right to remain silent would be custodial in nature, and the right against self-incrimination would be in other fora.
In your view, it is the forum where you invoke one and the other.
Well, like the Senate hearings yesterday, or the House hearings, if they want to remain silent, I mean, you cannot force them. It's the right against self-incrimination. If they invoke it, people have to respect it. I think that our legal system has provided for that.
Okay. Does the Office of the Ombudsman have legal standing to intervene on appeal in administrative cases resolved by it?
On appeal, Your Honor? On appeal with the Court of Appeals, let's say?
Yes, on appeal in administrative cases.
Well, it should have standing. It should be given standing. I think that the review of the actions of the ombudsman in court will entail its participation.
Can the doctrine of condonation be applied motu proprio by the Office of the Ombudsman?
To be able to forgive a wrong as it is, I think is something that would be very, very controversial. That can only be done if a person is to become a state witness or a whistleblower. Then we can condone what they have done in the past. But as a power itself, I think only the courts should be doing that.
Okay. Is the final and unappealable decision of the Office of the Ombudsman still be the subject of a judicial review?
Of course. Everything is subject to judicial review, I believe.
Okay. I think no more. Executive Order number 226 institutionalized the doctrine of command responsibility. What are the elements for one to be liable under said doctrine? What elements should be proved? That will be the last question from my colleagues.
The authority, power and authority.
Yes.
Number one is an element that's needed, a command. That power and authority is used for a decision by the people under the said authority, and that the authority would have to stand by the actions of those under him.
Oh, there are three actually. You name one. What are the other two?
An questionable action or action committed by underlings that may have been questioned later on.
Yes. What are the nature of those actions?
The carrying out of executive actions. I think that these are ministerial actions, or just actions that are part or parcel of the job being done by the person, or by the outfit involved.
How about the superior?
Well, the superior, in allowing such actions to happen,
Yes.
should be responsible for what has been done and what is being done.
And the last one is that he must not have direct participation. Okay.
Yes, sir.
In your program here, you already covered this. You said you're going to raise the probable cause standard to prima facie evidence. That is your circular, SOJ circular. But in the category, improve the clearance system, you wrote, requirements will be streamlined so only complaints with sufficient prima facie basis can hold up issuance. Can you explain that in the light of your earlier position or what you have been advocating, raising the probable cause standard to prima facie evidence with reasonable certainty of conviction?
Well, in the clearance
Regarding
system,
the
sometimes it becomes a headache for many people who are applying for positions when they have been with their cases pending, which have aged considerably and which have been pending for the longest time. And I think that the standard has to be raised as to why we keep cases alive. If the case does not contain any evidence, it's a cold case, we can dismiss it for subject to refiling without prejudice. But I think that we cannot hold people to account for something when the office is not doing anything to resolve the controversy.
Who will make such determination in the office of the Ombudsman?
I think the fact-finding will have to do it. The people who
It will also take time
well,
because you.
it's just it's yes or no question. We can actually dismiss a case without prejudice of refiling, because that is the only way to do it. If it is weaponized as such, then it's unfair. I don't think that it should be weaponized. I don't think that the office of the Ombudsman should be weaponized.
Secretary, are you impulsive?
No, sir.
No. In your line of work before, as a legislator, as a secretary, have you experienced stress or pressure? And how did you handle them?
Stress and pressure are always part of the job, I believe. As a legislator, during the corona hearings, there was a lot of pressure on us to follow Malacanang, but I refused. I just had to take it on the chin, whatever they wanted to happen. So I stood by my commitment and my belief that the process was being used to vilify a person without any due process, because what was filed against him did not contain many of the fishing expedition matters that became part of the evidence. I think that should never happen.
Secretary, can you cite an instance in your career when you made an unpopular decision because it was right and lawful? It was the right and lawful thing to do. And how did you handle the consequences?
My career as a SOJ, as a Secretary of Justice, or my whole career in itself?
The whole career. Just an instance when you made an unpopular decision.
Well, as governor, I had to fire people who were there for the longest time, but I just had to do it. Very unpopular. I mean, for the old timers in the capital, they frowned upon my action, but I think I was proven right.
How will you protect the office of the Ombudsman from becoming a tool for political harassment?
As I said in the opening questions,
Yes, you
we
go.
cannot allow the office of the Ombudsman to be weaponized by anybody. It should not be a tool for political battles, but people who want to really file a case should produce the evidence needed and should assist the Ombudsman in coming up with the evidence. And if there's no evidence, then we have to dismiss these cases.
Secretary, what is emotional quotient? if you know. What is your understanding? Ganun na lang.
Emotional quotient is EQ, or they call EQ, is a trait of a person who knows how to, in dealing with his peers and fellow man. I think that the sensitivity is very important in how we treat our peers and our fellow men. And that's the emotional quotient that is required from many of us in the jobs that we do, and probably most demanded from a politician.
Do you possess such quality?
I would believe so, sir.
Thank you. I think that will be all, Secretary. Thank you very much for your time.
Thank you very much.
Your excuse.
Thank you, Justice Mendoza, and thank you, Secretary Remulla.